क्या ट्रेडमार्क ऑफिस ने आपकी ट्रेडमार्क एप्लीकेशंस को रिजेक्ट कर दिया है, या फिर आप एग्रीव्ड हो क्योंकि ट्रेडमार्क ऑफिस ने एप्लीकेशन पब्लिश करा, एडवर्टाइज कर दिया ट्रेडमार्क की एप्लीकेशन को, लेकिन ओपोनेंट ने ओपोजिशन फाइल करी और ट्रेडमार्क ऑफिस ने ओपोनेंट के फेवर में डिसीजन दे दिया और आपकी एप्लीकेशन ड्यूरिंग ओपोजिशन प्रोसीडिंग रिजेक्ट हो गई। या फिर आपके ही कंपटीटर ने फ्रॉडुलेंटली पहले ट्रेडमार्क एप्लीकेशन फाइल कर दी थी, लेकिन आपने ओपोजिशन फाइल करा और जो फाइनल ऑर्डर ओपोजिशन प्रोसीडिंग्स का आया वो ट्रेडमार्क एप्लीकेंट जो कि आपका कंपटीटर था या आपका वेंडर ही था, उसने पहले फ्रॉडुलेंटली ट्रेडमार्क को अप्लाई कर दिया और आज वो आपको ही रोकने के कगार पे है। तो क्या डिसीज़न ऑफ ए ट्रेडमार्क ऑफिस एक फाइनल डिसीज़न होता है या उस डिसीज़न को हम चैलेंज कर सकते हैं? आज इस वीडियो में आई एम गोइंग टू डिस्कस कि इफ़ यू आर एग्रीव्ड बाय द फाइनल ऑर्डर और डिसीजन ऑफ द लर्नड ट्रेडमार्क रजिस्ट्रार ऑफ द ट्रेडमार्क ऑफिस इन इंडिया, then you have the opportunity, you have the right to file an appeal against such order or the decision. Let us now get deeper into understanding what are the various requirements, what are the various timelines, and under which circumstances you can file an appeal against the final order or the decision of the trademark office. The first thing which we need to understand is that refusal by the learned trademark registrar is not the final word against you. So अगर आपको एक रिफ्यूज़ल ऑर्डर मिलता है आपकी ट्रेडमार्क एप्लीकेशन के अगेंस्ट या आपकी ओपोजिशन प्रोसीडिंग्स के अगेंस्ट, या आपने ट्रेडमार्क एप्लीकेशन फाइल किया था और ऑर्डर इन फेवर ऑफ ओपोनेंट के फेवर में जा चुका है, तो देन it is not the end of the process. ट्रेडमार्क एक्ट जो है हमारा, ट्रेडमार्क एक्ट 1999 provides a structured path to challenge such orders or the decisions of the learned trademark registrar. And जो appellant है, जो कि ट्रेडमार्क एप्लीकेंट भी हो सकता है या एक ओपोनेंट भी हो सकता है, they have a statutory right to file an appeal under section 91 of the Trademark Act. We will go through all the requirements, we will go through in detail under what are the various circumstances in which you can file an appeal against the order or the decision of the learned trademark registrar. So before moving further, it is very important for us to understand about the IPD, that is the Intellectual Property Division of the Honorable Delhi High Court, and why it is very critical specifically for the region which falls under the category of Delhi Trademark Registrar Office. Because पहले क्या था, इंडिया में IPAB इंटेलेक्चुअल प्रॉपर्टी एपिलेट बोर्ड था, जिसका प्राइमरी ऑब्जेक्टिव ये था कि ट्रेडमार्क ऑफिस के फाइनल ऑर्डर्स या डिसीजंस को, अगर कोई भी व्यक्ति, वो ट्रेडमार्क एप्लीकेंट हो सकता है या ट्रेडमार्क ओपोनेंट हो सकता है, इफ़ ही इज़ एग्रीव्ड बाय द डिसीजन ऑफ द ट्रेडमार्क रजिस्ट्रार, देन ही हैज़ टू अप्रोच टू द IPAB. लेकिन जो ट्राइब्यूनल्स रिफॉर्म्स एक्ट 2021 आया, उसके बाद से ये IPAB कम्प्लीटली एबॉलिश कर दिया गया, एंड होल पावर्स in relation to the appellate jurisdiction of IPAB were transferred to the respective high courts of the state. तो उस कारण से क्या हुआ, जितने दिल्ली के ट्रेडमार्क ऑफिस के से जो अपील्स जनरेट हुई थी बिफोर द IPAB, दे गॉट ट्रांसफर्ड टू द इंटेलेक्चुअल प्रॉपर्टी डिवीजन ऑफ द ऑनरेबल दिल्ली हाई कोर्ट. एंड नाउ after the abolishment of the IPAB, after the enactment of the Tribunal Reforms Act 2021, agar any person if has to file an appeal against the final order or decision of the learned trademark registrar who has filed the trademark application before the Delhi Trademark Registry, or who has filed the opposition against a pending trademark application filed before the Delhi Trademark Registry, they have to invoke the jurisdiction of the Honorable Delhi High Court and the appeal will be listed to the IPD, Intellectual Property Division of the Honorable Delhi High Court. So going further, let us discuss कि briefly grounds of appeal होंगी क्या. Grounds of appeal, let's consider in two categories mainly. अगर आपने ट्रेडमार्क एप्लीकेशन फाइल करी है, ठीक है, तो आपकी ग्राउंड्स ऑफ अपील में मेजरली वन काइंड ऑफ कैटेगरी वुड बी एब्सोल्यूट ग्राउंड्स फॉर रिफ्यूज़ल, जिसमें ट्रेडमार्क ऑफिस ने आपकी एप्लीकेशन को रिजेक्ट कर दिया है, ठीक है. जो सेक्शन 9 हमें पता है, जो ट्रेडमार्क एक्ट है, वो फोकस करता है एब्सोल्यूट ग्राउंड्स फॉर रिफ्यूज़ल के ऊपर. दूसरा ग्राउंड्स आ सकती हैं अपील में जो जनरेट होंगी, वो आएंगी रिलेटिव ग्राउंड्स फॉर रिफ्यूज़ल. दीज बोथ ग्राउंड्स आर पर्टेनिंग टू प्राइमरीली टू द ट्रेडमार्क एप्लीकेशन, ठीक. Another category of grounds जिसमें you have to focus upon is the procedural grounds, ठीक है. Many times we have experienced that hearing was scheduled लेकिन hearing link ही नहीं मिला, right? And sometimes उसको अगर hearing link नहीं मिला तो trademark office assumes कि link मिला था, and the opponent or the trademark applicant has knowingly not appeared before the registry, and that's why the trademark application got rejected. So these are the key you consider that the procedural grounds are there where the principles of natural justice are completely overlooked by the trademark registrar, and your grounds for filing an appeal becomes very focused depending upon the nature of flaws in the final order or the decision issued by the learned trademark registrar. So let us now quickly go through with some examples on the absolute grounds for refusal, relative grounds for refusal, and the procedural grounds जो कि रेस करी जाती हैं for filing an appeal against the order or the decision of the learned trademark registrar. So typically when you have filed a trademark application और आपकी trademark application अगर reject हो गई है on the basis of section 9, तो typically we have seen the final order, disposed of order, generally one line comment is there कि the mark is considered incapable of distinguishing the goods or services of one person from another, right? So इस तरह की objections को what we have done is that we have gone through the various recent judgments and given you some samples how the the various grounds were considered by the Honorable Delhi High Court. In first example, if you see that the lack of distinctiveness and the anti-dissection rule, right? As a trademark attorneys, we are aware that the trademark must be considered as a whole. You cannot dissect it and say that okay, this part is already available resembling with let's say already existing brand A, the another part is already comparable with the brand B, so that is why we cannot allow you the trademark registration for the combination of these things, right? And that's where the Honorable High Court has considered and established various principles that you cannot apply the dissection rules. You have to assess the trademark as a whole. Okay. Second is many times the coined and arbitrary marks are there, right? And you have to bring forth such importance of coining the words or arbitrary marks so that you can achieve the level of distinctiveness in your brand name. Even after raising these arguments, if your trademark application got rejected, then you have to assess the situation. You have to go the arguments, you have to go the reasons based on what the learned trademark registrar has rejected your application, right? Third very critical and very common factor is that when many times when the trademark applicant filed a trademark application on the basis of proposed to use. Okay, and let's assume that after 3 years, 4 years, the application got rejected, but the trademark applicant was using the trademark since the time of filing the application. Okay, so at that time you have to bring forth various evidences establishing that because of the usage your mark has acquired a distinctive character and public recognition even before the date of registration. So these are the various instances in the recent judgments passed by the Honorable Delhi High Court, where the Honorable Delhi High Court has set aside the impugned final order or the decision of the Learned Trademark Registrar when the Learned Trademark Registrar has rejected the application on the basis of Section 9. So let us now move to the another set of objections where the the Learned Trademark Registrar rejected it, and when the matter reaches out to the Honorable Delhi High Court, the issue was primarily on the Section 11 grounds. Let's see. So many times the core issue would be that the mark is refused due to its similarity to an earlier mark, creating a likelihood of public confusion. So this is many times you will receive such type of language in your rejection order, and that's where you need to assess whether it is really whether my mark is really creating a public confusion or likelihood of creating a public confusion. What are the chances of having such confusion in the minds of end consumer? Okay, so in couple of judgments the Honorable High Court held that even if the marks are similar, the goods or the services are so different that there is no range of confusion. Okay, so if you are dealing, so what does that mean is that if the trademark registrar has cited some brands against your trademark application, and the earlier brands which were filed by someone else, the third party, and that brand relates to certain other goods or certain other services in which you are not at all involved, then the argument on the basis of which the Learned Trademark Registrar has rejected your trademark application, that there is likelihood of confusion, is not correct. So the Honorable Delhi High Court has held that if the goods or the services are different, then how much is the likelihood of confusion is there, that has to be assessed, and this is going to be a different in certain industrial areas also. For example, if we compare in the pharmaceutical industry, the Honorable High Court has a very rigid standards, okay, strict standards, because it relates to the public health. So a higher standard of care is applied to medicinal products to avoid risks to public health. For example, fluoresces versus flora. So to end consumer, to us, as a trademark applicant, it may seem that we are different, but considering my domain in which I am going to sell this product, the Honorable High Court has held that there is likelihood of confusion among the end consumers. So the trademark application was rightly rejected by the trademark office, right? The third important factor which you must consider is prior rights. The appellant has prior and continuous use of the trademark, establishing a superior right. So in the trademark jurisprudence, prior use is one of the basic factor to establish the rights of a particular party over a particular domain or a trademark. Okay, if you can establish that you have a prior use for a particular brand name when it is compared with some other competitor, when it is compared with some other third party, then the decision will definitely go in favor of you for ensuring that you get the trademark registration. But at the same time, you must be a continuous user, okay, from the date of claiming of your prior use. Then another grounds which we have seen is that the inconsistency by the registrar. At times we have seen that sometimes the learned trademark registrar accepts the application for the same kind of goods or services for a particular brand name which is resembling with already existing brand names, and we have also seen that in other applications the trademark registrar has rejected the trademark application under the same circumstances. So these kind of inconsistency, if brought before the Honorable High Court, that can be a positive factor for you to get your application accepted by the Honorable High Court at the appellate jurisdiction level. So let's now go to another critical examples of grounds for procedural related issues. Okay, these type of typical grounds are generally relied upon during the process of the opposition proceedings, right? When the hearings, for example, hearing notices were issued and you did not receive the actual hearing notice, or you have changed your trademark attorney and the hearing notice was received by the earlier trademark attorney, right? So these are the certain grounds which entitles you to file an appeal before the Honorable Delhi High Court. So let's quickly go through these two key arguments which are generally referred to. First is improper service of notice. The timeline to respond begins from the actual receipt of the notice, not just when it was sent via email. The application deemed abandoned without proof of service can be challenged. Okay, so this was a matter where the trademark registry has held that the trademark registry sent a proper notice, but they were not able to give any proof of service. So the Honorable Court held that without presence of any proof of service, it was wrong on the part of the trademark registry to reject the trademark application. And then another type of procedural lapse is here. An opposition was wrongly deemed abandoned for filing a photocopy of evidence instead of original, especially in an era of e-filing. This denies a party a fair hearing on a minor procedural issues. So basically, if because of procedural lapses, your substantial right or is getting affected, your right to oppose a trademark application, your right to get a statutory protection of a particular trademark, then the Honorable High Court generally gives due attention to such procedural lapses and provides at least one opportunity to the appellant, who may be a trademark applicant or who may be a trademark opponent. So having disclosed these types of various procedural as well as substantial grounds which helps you to file an appeal before the IPD of Honorable Delhi High Court, let's now go to the section 91, which empowers the Honorable High Court to adjudicate such matters. So section 91 in itself provides a complete picture of various important appeal related processes as well as the timelines. Let's go through the section 91 once. Any person aggrieved by an order or a decision of the registrar under this act or the rules made thereunder may prefer an appeal to the High Court within 3 months from the date on which the order or the decision sought to be appealed against is communicated to such person preferring the appeal. So subsection 1 of the 91 says, if you are an aggrieved person, it is not written that only trademark applicant can file an application, only trademark opponent can file an application. You have to satisfy the standard that you must be a person aggrieved. Only then you will be able to file an appeal under section 91. Okay, within how much time? 3 months. You have 3 months from the date when the order which you want to challenge must have been communicated to you. Okay, on the receipt of the order you must file the appeal within 3 months before the respective honorable high court. Second, so let's understand the importance of subsection 2 also. No appeal shall be admitted if it is preferred after the expiry period specified under subsection 1, that is the 3 months, provided an appeal may be admitted after the expiry of the period specified therefore, if the appellant satisfied the High Court that he had sufficient cause for not preferring the appeal within the specified period. So subsection 2 gives flexibility to the appellant if the deadline is missed. But you cannot simply remain silent even for the expiry of 3 months, and you cannot be a casual in your approach while dealing with the appeal process. Let's say for example आप किसी अनफॉर्चुनेट इंसिडेंट के साथ डील हो गए कि आपका एक्सीडेंट हो गया, बिकॉज ऑफ दैट यू रिमेन बेड रिडन फॉर 1 month or 2 months, and that's why you filed the appeal after expiry of 3 months and after even further 2 months. So जो additional 60 days का time है, अगर वो sufficient cause है, right, because of which you were not able to file the appeal within 3 months, then the Honorable High Court may consider it, may condone your delay in filing the appeal before the Honorable High Court. So what does this mean is that if you are filing the appeal after the expiry of 3 months, you must file an application seeking condonation of delay in filing the appeal, and the reasons should be sufficient cause for not preferring an appeal within the 3 months, right? And then subsection 3 is basically more on the what kind of forms you need to use while filing an appeal. Every high court, be it a Bombay High Court, be it a Madras High Court, they might have their own forms, they might have their own requirements, so you have to comply with those requirements in order to file an appeal before the respective high court. So quickly, if we understand the gist of section 91, who can appeal? Any person aggrieved. Okay, so aggrieved person, generally if we bring down the various circumstances, various scenarios, if we analyze various scenarios, the output would be that a trademark applicant जिसका mark refuse हो गया है, वो aggrieved person है, he can file an appeal under section 91. An opponent जिसने opposition file करी because of XYZ reasons, right, उसकी opposition dismiss हो गई, तो वो appeal file कर सकता है. A trademark applicant जिसके against opposition file हुआ, उस opposition के कारण, राइट, उसका एप्लीकेशन जो है अबंडन हो गया या उसका एप्लीकेशन रिजेक्टेड हो गया, देन ही कैन फाइल एन अपील अंडर सेक्शन 91. देन थर्ड, ए पार्टी एडवर्सली अफेक्टेड बाय ए कैंसलेशन प्रोसीडिंग्स, राइट. मैनी टाइम्स रेक्टिफिकेशन फाइल कर दिया जाता है against the trademark which is already registered. So in that case, the various parties who are getting affected by because of the rectification proceedings के आउटपुट से, those are entitled to file an appeal under section 91. So quickly, the timeline is 3 months, and if you file the appeal before the Honorable Delhi High Court, जो nomenclature मिलेगा उसको, CA, that is CA, civil appeal, and COM means it's a commercial dispute, and IPD is intellectual property division, and matter is trademark. Okay, जो कोर्ट फी है, कोर्ट फ़ी 10,000 रुपीज़ है, और जो फॉर्म 2 है ऑफ द दिल्ली हाई कोर्ट IPD रूल्स 2022, वो यूज़ होगा टू फाइल एन अपील बिफोर द IPD ऑफ ऑनरेबल दिल्ली हाई कोर्ट. So that's pretty much sums about the section 91 and the various other requirements. So now let's move to the Honorable Delhi High Court requirements and try to understand कि उस process में कितना time लगेगा, उसमें क्या मेरे को result मिलने वाला है. Let's quickly go through these scenarios also. अच्छा, अपील मेमो में क्या डॉक्यूमेंट्स रहेंगे जो मैंडेटरी है, राइट. मोस्ट ऑफ द टाइम्स एक मेमो ऑफ अपील में मेमोरेंडम ऑफ पार्टीज तो रहेगा ही रहेगा, जिसमें एपिलेंट जो ट्रेडमार्क एप्लीकेंट है या ओपोनेंट है वो रहेगा, एंड द रिस्पोंडेंट्स. अगर देखो, अगर आप ट्रेडमार्क एप्लीकेंट हो, राइट, देन ओनली रिस्पोंडेंट इज़ गोइंग टू बी द ट्रेडमार्क रजिस्ट्रार ऑफिस जिसने आपकी एप्लीकेशन को रिजेक्ट कर दिया. लेकिन अगर आप ओपोनेंट हो तो देन along with the trademark registrar you have to also include the trademark applicant as a party, as a respondent. Without that your appeal would not be listed before the bench of the Honorable Delhi High Court. Okay, other requirements are, one is synopsis and a list of important dates, brief memorandum of appeal summarizing the case, and this is very critical, a clear and concise grounds of challenge against the impugned order. So if you are, let's say, the principles of natural justice are not followed, then you must clearly articulate in your appeal memo under the grounds of appeal. It must be listed that because of let's say loss of hearing link, you were not able to attend the hearing, and that's why the decision was decided in absence of your in your absence only. Okay, so the principle of natural justice has been violated, so such kind of grounds has to be listed. Okay, then the copy of the impugned order, obviously जिस order को आप challenge करने वाले हो उसकी copy रखेंगे. The sworn affidavit of the appellant verifying the contents of the appeal, this is standard requirement. A disclosure of any prior litigation pending between the parties concerning the same dispute, this is also a critical. Okay, many times if you let's say for example if you are not disclosing it clearly, okay, then your intention would be questioned, and once your intention, once your conduct is questioned before the high court, your chances of getting the relief gets dim. Then finally record from the IPO, all the documents whatever, let's say if you are filing an appeal against the rejection of your trademark application, then the documents in relation to the examination search report, right, any other documents, if you have filed the evidence of use along with the filing of your trademark application, so all such documents whatever it is there, you try to file it with before the Honorable Delhi High Court also. Okay, so let us quickly have a quick look on the rules of additional evidence. Okay, so the documents that were not part of the IPO record are generally not accepted at the appellate stage except with the express permission of the Honorable Court. So at the appellate stage this typically happens when you are challenging an order of let's say passed during the opposition proceedings. The certain documents must have been filed and you want to bring some additional document at the appellate stage, then you have to seek leave of the court to file the additional documents at the appellate stage. So once these all documents are filed properly before the registry of the Honorable Delhi High Court, then the matter is listed before the single bench, and typically if you see the timelines of the recently let's say 1 to 2 years of matters, generally within 1 to 2 years your appeal gets disposed of, right? लेकिन relief क्या मिलेगा? Relief, that's important. Okay, many times we have seen the Honorable Delhi High Court set aside the registrar order itself कि भाई आपने trademark application reject करी है, we are setting aside that order and we are actually going for allowing the application and you now may please advertise it for the further steps as per the Trademark Act. Okay. Then in certain cases, especially in the contentious matter, if for example in the opposition proceedings, the Honorable High Court may remand back the matter to the Trademark Registry for re-evaluation. Okay. The High Court may allow the opposition to succeed also. High Court may dismiss your appeal altogether itself, okay, or may impose a cost on you also if you are filing the frivolous appeals. So that's pretty much sums up what kind of relief you are about to get from your appeal filed at the Honorable High Court. So now if I conclude the overall the trademark appeal filing process, key pointers is the trademark refusal is a challenge है, आपकी application reject होगी, आपके ऊपर cost भी पड़ेगा, आपके ऊपर some timelines gets changed, लेकिन it's not a dead end. Okay. अगर आज के समय में मैं कंपेयर करूं विद दी परफॉर्मेंस ऑफ दी IPAB इंटेलेक्चुअल प्रॉपर्टी एपेलेट बोर्ड, जिसमें मैटर्स जो थे 10 साल 5 साल से लेके 10 साल टिपिकल टाइम लगता था इवन फॉर रिसीविंग एन ऑर्डर अगेंस्ट द रिजेक्शन ऑफ द ट्रेडमार्क एप्लीकेशन, तो इन ऑर्डर्स को भी चैलेंज करने के बाद 5 से 10 साल तक फाइनल अपील डिस्पोज ऑफ होने तक का टाइम लगता था बिफोर द IPAB. बट बिफोर द ऑनरेबल दिल्ली हाई कोर्ट देयर आर फेयर चांसेस दैट you may get success within 1 year or maximum within 2 years for in the appeal matters before the Honorable Delhi High Court. Okay, and your success in your appeal definitely going to rely upon when you are clear about the substantive law and the procedural rules. Okay, if you are not clear, if those issues, those grounds are not raised in your appeal memo, then the chances of getting success are not high. But if you are clearly pointing out such grounds for refusal in your appeal memo, then the High Court definitely would look into such grounds, and depending upon the facts and the circumstances of the case, the High Court may dispose of the appeal in your favor or in the opponent's favor. It all depends, right? But you need to be very carefully pinpointedly disclose the various grounds of appeal. Okay. And if I conclude it by saying that a well prepared case can turn a refusal into a registered and valuable trademark, and I must add here, and that a well prepared case can turn an advertised trademark application into a rejected trademark application also if you are on the opponent side. So I hope this video would have helped you to understand briefly about the requirements of filing an appeal against the final order or the decision of the learned Trademark Registrar, and we have also explained other aspects of intellectual property rights, especially in relation to the trademark rights. You can go through such videos in our description box, and do share this video with your friends or the other stakeholders who are going through a challenging phase where they have received an adverse order from the learned Trademark Registrar. And in case you have any specific questions or queries, you can write down to us at info@nyaytantra.com, or you can drop us a WhatsApp message at the number below, as well as you can put up in the comments your basic queries. We will try to respond to your queries as soon as possible. And don't forget to like and subscribe to this channel. This would help the team who is working hard to narrow down the complexities into simpler language. And thank you very much for going through this video. Jai Hind.